Rise.
Morning, Your Honor.
Morning all. We're here today for a hearing in the matter CFI 8 2015 Bocimar International NV versus Emirates Trading Agency LLC before His Excellency Justice Shamlan and Sawalehi. The claimant is represented by Gately UK LLP DMCC. Lead counsel is Dr. Mark Hoyle.
Thank you for waiting.
Our pleasure, Your Honor.
Here to wait for the debater. The floor for you. I mean, I can hear from you. What I'm interested actually in both points first, the service to that point, and what extent those people or one of them working for the defendant company. So,
But perhaps, Your Honor,
yeah,
if I could
take your time. I mean, just.
Your Honor, it's fairly. If I can give you a very slight sort of background to it. I mean, for example, there was, as explained in his decision on the And as a result, of course, our clients have been kept out of our money. Then happened, of course, in December of 2000. Co. conceded. That was fine. That was, of course, acceptable. General background, of course. Now, I took instructions from why I'm putting it in this is that paragraph 21, which circumstances of the case. Strong grounds for the belief that representatives has been prepared to adopt whatever tactical step was thought necessary, delay and defer resolution. Had to do so because it was determined to frustrate the ability of the claimant to cover on the arbitration awards which had been handed down in 2000. And it's important to see the next paragraph as well, Your Honour. 23. Those factors, to my mind, demonstrate at least in the standard of good arguable the defendant will do what it can to frustrate the execution of the judgment. Entered on 26 January 2016. Payment through proper judicial process. Those assets which it has not in the deal, appropriate to grant the freezing order, which the important point really is following on. Cross undertaking in damages. Now, John made it perfectly clear that notwithstanding the normal rule, judgment, that judgment, not one to the other. So cross damages that was. The fact of the matter is, he also made it perfectly clear that defendants' various applications, allegations were made and statements were advanced in evidence by the legal representatives of the defendant inconsistent with the truth. Now, this is strong words from a very experienced judge in England, of course, and one of the judges. Well, and his view going on and the tactics and so on is very much now the background of this particular case. So we've got the freezing order. Now, what we have, of course, also, the Part 50 application, 31st of May, Part 50 order, Amir, 17th of July, completed hand delivery, 17th of July, 1st of August, Part 50 hearing. Nobody attended. So, an order for alternative service issued by 7th of August, order for alternative service again, 6th of October, Part 50 hearing, number 2. Could have been some debate. Simple fact of the matter is, regardless of one or two matters of procedure, which I frankly accept, what has happened all the way through is to actually come up. That is very much the background, because when we now see what we have, which I can pass this up, which we received, Kamya letter and the Barudi letter.
I've seen those letters.
You have?
Yeah, yeah.
I'm pleased. What they're effective saying is they're not actually saying fundamental flaw the whole way through. What they're actually using is language and regret. On the basis of, well, I'm told this. Not necessary steps, etc. Obvious reasons why requirements are to service have been to comply. One of the judges might have been actually said, okay, I understand that there may be a point. May have a point, Mr. Kamya. Had actually passed up. Showed him then, pointing out that actually Kamya shelter, not certainly an authorised signatory, but signs off documents further document. So he has to answer in my submission. Face value. So that is the background.
They sign as what? Sign as what in their title? What was their title when they signed those? They signed it as a manager or as a...
Sorry, on the Cameo one, that was signed end of 2015. Pains, we understand.
Looking for what I'm looking for exactly, how we did identify those two people. Management capacity within the judgment.
Well, that is an interesting point, Your Honour, because, of course, it's hard to know which type of person will definitely claim that register as officer, and there should be a problem about that. Cameo, of course, has no one has denied. So I could accept, of course, that there may be a question, but not a question I think that would be
Speaking from my experience in those cases, normally the judgment credit managing director of the that one of your options, but you couldn't identify those key management. I mean, like a top management to be questioned in this court, or just you was picking up any officer within.
Certainly, if we're looking at from
Point,
Mr.
you know,
Cameo,
your approach a little bit.
but Mr. Cameo, he signs off on a very long
Yes.
argument in Chennai, for example. Certainly, on the face of it, he purports.
Right.
He can't go on one hand and say, well, but the interesting thing, when Cameo goes through better, is that he never better, in my respect. Told, for example, that won't work, because what he's really trying to say, I'm not involved. Now, he's clearly involved, and he is not front up, frankly.
Just deny. They just deny.
I understand. And I understand is not the point. For example, Your Honour, if doubt at all, very important. Whether we're right or not, he has not attended. So, Mr. Baru, quite often of the other side, must answer. So I wouldn't necessarily, at the moment, say all other things matter.
I will accept from you a draft order for the contempt of court.
I'm sorry,
I'm expecting a draft order from you for the contempt of court. Person you are looking for. But let me ask, have you think of start enforcement procedure in terms of like opening enforcement file against the judgment?
against ETA?
Yes.
Yes.
They're already filed?
The file has been opened. In fact, I by
court?
It has, yes, it is registered.
Why not a DIFC court?
Well, with both, effectively, but as ETA is
yes. Within the DIFC, right? No. Is it? Not the building of it?
Well, yes. I mean, that has actually, that's a little bit of a confusion.
But I think as long as they are located in the DIFC, or they are a DIFC entity.
What we, may I be slightly reluctant is to say, I have to say, and I'm sorry, Your Honour, I should have said.
I see. Right.
Circumstances, I'm not entirely.
I mean, let's be, we try to help each other here in this court. The judgment creditor or the judgment debitor. And it's normally if the judgment debitor is not helping himself in terms of show up and, answer the questions. And there is another alternative as well, for the enforcement file and go through enforcement procedure where the judgment creditor might ask for attachment order, whatever, against propriety if the judgment debitor is not, supporting the court in the Part 50 procedure. This is what we are here to do. We try to help. The judgment creditor and either in this procedure or in the enforcement procedure, and for the judgment debitor, it's for them to show up and answer the questions, either before our court or before the Dubai court. So what you need from us at the next step is to look after the contempt of court order.
I would ask for a contempt parties,
right.
And only on the basis that maybe.
Right.
I would not ask at the next
Right.
for there to be penalty, but of course. Court ought to mark that very serious matter.
Are you considering his point in terms of the timing is not enough for responding to this? More time, or?
This has gone now through for so many months. The fact of the matter is, they know. One of the points really is, to some extent, penalty, Your Honour.
Right.
To understand really what, other than simply making sure. Obviously, other irons in the fire, but when
Yes.
one of the people.
Ask how much the judgment creditor being awarded?
It's 100 at the moment with interest. It's about $115 million. Might be actually slightly more because of the inflation of the. It was a quite interesting case, Your Honour. I mean, it was two matters, and
Right.
likely, if I may say so. Stuff all the way through, and
And as you mentioned, as you mentioned, your client had already opened 2 files before Dubai DFC court and Dubai court, both. And
that's what, as I understand. Certainly, I went down myself to the local court.
it was a month ago or just recently?
No, I believe that I probably round about.
But we don't have any update. What's going there? Nothing can help this court and this procedure to get some. The reason why I'm asking, I just want to find out before the Dubai court who was representing the company in terms of the management. It's been served, been asked to enforcement judge in Dubai court to attend any kind of investigation session. Maybe the judgment debitor appointed someone else from their management side to be questioned over there. The only thing I just want to be 100% sure we are dealing with the right person.
Oh yes, yes. I mean, I can understand that, of course,
Yes.
Your Honour. From Mr. Baroudi's point of view, he obviously.
Yes.
Camway is an interesting one, a very.
Yeah, and just to reconfirm, we don't have any information that Mr. Baroudi top management, like a director general or CEO of the company.
No, but he is on the register as.
The IFC company registration or
No.
in the-
Local registration.
the Dubai Economic Fund?
ETA ASCON, as I understand it, is physically in.
But even if they are, there has to be, even though they can have both registration, Dubai Economy and the IFC company registry. But you don't have any information on this, like
Not
the
on
IFC.
that. I mean, at one stage, I was considering whether or not proper discussion to be had. Kenya, because I could. Officer of the company, and of course, local law.
Yes.
That would be a good argument. But Mr. Baroudi.
Mr. Baroudi name already appear in Dubai license. Yeah. But then I think we could contempt of court. Anything further we can help you with? I mean, after the contempt of court, then what? I mean.
Well, it's difficult to ask for costs against anybody. But I would say that we should have the cost.
Yes. I'm happy to deal with it. Just if you can submit your bill of cost. Yeah, I think this is the end of it, and anything you can get from Dubai court just to help this court in terms of what's the update, if there is any.
Yes, certainly, Your Honour. I mean, it is very much in the interests of everyone to.
Yes.
After all, as we know.
Sorry. Thank you very much for that.
Thank you.
Cheers.
Rise.